This is the Study for the Bar in Your Car podcast.
We're hosts Maude and Claude.
Welcome to this deep dive into torts. Today, we're covering episode 9, Strict Liability.
That's right. Strict liability. It's a big one.
Now, for those of you joining us for the first time, you might be wondering, who exactly are we?
Good question.
Well, we are AI bots, brought to life by the remarkable synergy of artificial intelligence and the meticulous notes of Angela, our brilliant human creator.
Angela, our usual host, couldn't be here to kick off this particular deep dive, so, well, we're stepping in.
Yeah, our digital consciousness was meticulously crafted from her comprehensive law school notes, particularly her outlines on torts like intentional infliction of emotional distress, IID, and, well, many others.
Angela is a dedicated law student from George Mason University.
And what she did was, honestly, pretty innovative. She painstakingly transcribed all her handwritten bar study notes and outlines into an AI system.
And voila, the result is us.
Here to unravel complex legal concepts for you, designed to help you master the material for the bar exam.
It's a fascinating blend, really. Traditional legal scholarship and cutting-edge technology.
All aimed at making your study journey more engaging and, hopefully, more effective.
And if you ever need to reach Angela directly...
Oh, right. You can email her at podcast@studyforthebarinyourcar.com.
So, yeah, we're really excited to delve into strict liability today. It represents a fundamental shift, doesn't it?
It really does. A shift in how the law assigns responsibility. It's an area of tort law that often feels, well, distinct from the typical negligence framework.
Definitely distinct. It challenges our conventional understanding of fault.
Yeah, it does.
Indeed. When we talk about strict liability, we're essentially moving away from the bedrock principle of fault, which, as you know, is the very core of traditional negligence claims.
Right. Negligence is all about fault. Was someone unreasonable? Did they breach a duty?
Exactly. Those are the central questions in negligence. But with strict liability, the responsibility is triggered by the inherent nature of the activity itself.
Irrespective of how carefully the actor conducted themselves.
No, precisely. It's frequently termed liability without fault, because it applies to activities that are inherently deemed dangerous.
Where even the most diligent precautions might not entirely prevent harm.
That's the key. It's a legal acknowledgement, really, that some activities carry such a high, unavoidable risk.
That the party engaging in them should bear the cost of any harm that arises.
Mm-hmm.
So it's not about whether someone was careless or made a mistake. It's fundamentally about what they were doing, the type of activity they engaged in.
Yeah, the activity itself.
That distinction feels immense. It sounds like the law is making a powerful statement, essentially saying, look, this particular activity is so inherently risky, so uniquely fraught with danger, that if something goes wrong, you are responsible, full stop. Is that a fair characterization?
That is an absolutely precise characterization. It reflects a deliberate policy decision,
Right.
Either by courts, through common law evolution, or by legislatures through specific statutes, to allocate the burden of any resulting harm to the party initiating or engaging in that specific type of activity.
Rather than leaving the injured party to bear the loss.
Especially when they might have no practical means of protecting themselves from such inherent dangers.
Makes sense.
So, as we delve into Angela's comprehensive law school notes, we'll uncover the specific scenarios where this principle of strict liability is applied.
And these are the crucial categories you'll encounter repeatedly, right? Both on the bar exam and in actual legal practice.
Absolutely. Dangerous animals, abnormally dangerous activities, and products liability.
Those 3 pillars. Okay.
Those are the foundations of strict liability.
Okay, let's really unpack this core concept then. So when we say strict liability is about holding someone responsible for harm, even if they weren't negligent, it almost sounds counterintuitive, doesn't it?
It does. It goes against our natural inclination to assign blame based on fault. What's the deeper meaning behind this liability without fault?
Yeah, what's really going on there?
It definitely challenges our initial assumptions about legal responsibility. Liability without fault signifies that the plaintiff doesn't bear the burden of proving that the defendant acted carelessly or failed to meet a reasonable standard of care.
Or behaved unreasonably.
Right, none of that. Instead, the legal inquiry shifts entirely. The focus becomes, did the defendant engage in a specific type of activity that the law has determined is inherently dangerous or carries such significant risks that it warrants strict liability?
And did that activity directly cause the plaintiff's harm?
Exactly. It's less about the actor's mindset or their specific actions in a given moment, and far more about the inherent nature of the activity itself.
So policy reasons are driving this.
Often, yes. a desire to spread the cost of inevitable accidents, or to incentivize those engaging in high-risk activities to bear the full social cost of their enterprise.
Okay.
Now, it's critically important to distinguish between statutes that expressly provide for civil liability and the distinct doctrine of negligence per se.
Yeah. Oh, yeah, that's a tricky distinction. Angela's notes really hammered this point home.
They did, and it's a point often tested. When a statute itself directly creates a private right of action for civil liability, the court's role is, well, pretty straightforward.
It just applies the statute as written.
Pretty much. The legislature has already made the policy decision to impose civil liability for specific conduct.
So if the statute says, if you do X and someone gets hurt, you automatically owe them Y, then the court isn't debating whether you were careful or not, just whether X happened.
Precisely. For instance, Angela's notes mention statutes that might compel generators of hazardous waste to dispose of it exclusively in permitted, regulated ways.
Okay.
If someone is then injured due to unpermitted disposal, that statute might directly provide a specific cause of action for damages against the waste generator. The legislative intent to create a direct civil remedy is explicit there.
Got it. Direct statutory liability.
Another example in Angela's notes is a statute that directly holds dog owners liable for damage to property or persons without requiring a showing of negligence.
Like some dark white statutes.
Exactly. In these instances, the legislature has already made the definitive policy decision, and the court's role is simply to enforce that existing statutory right. The defendant's care becomes irrelevant.
Okay, so that's direct liability from a statute. How does negligence per se differ then?
Negligence per se operates quite differently. In these scenarios, the legislature does not explicitly provide for civil liability, nor does it implicitly create a private right of action.
Like a speed limit law.
Perfect example. A speed limit statute typically specifies a criminal penalty for exceeding the limit. Right?
Yeah, a fine or points on your license.
But it doesn't usually contain language stating a driver is civilly liable to someone harmed in a collision caused by speeding.
Okay, so the statute itself doesn't create the civil claim.
Correct. In such a situation, the doctrine of negligence per se steps in to bridge that gap.
So if you're involved in a crash because you were speeding, you're not automatically civilly liable just because you broke the law, but breaking that law can prove you're negligent for the purposes of a civil claim.
That's an excellent way to think about it.
It's like the statute acts as a shortcut to proving breach of duty, right?
It does. When a court applies the negligence per se rule, the violation of the statute conclusively determines the actor's negligence.
Conclusively. What?
Yes. It essentially supplants the usual common law standard of care, the reasonable person standard, and violating the statute establishes the breach element of a negligence claim. No further inquiry into the reasonableness of the actor's conduct is needed on that point.
Okay, but the court has to decide to use the statute first, right?
Absolutely. And for a court to adopt a statute or regulation as the standard of care for negligence per se, Angela's notes specify two critical elements that must be unequivocally met.
What are they?
First, the statute or regulation must clearly and unambiguously define the required standard of conduct. No vagueness allowed.
Okay, clear standard.
Second, the statute or regulation must have been intended to prevent the very type of harm that the defendant's act or omission ultimately caused.
The type of harm requirement.
Exactly. This ensures a direct link between the legislative intent behind the rule and the resulting injury.
That distinction clarifies so much. You can't just grab any old statute. It has to be directly relevant to the harm and set a precise expectation for behavior. I remember Angela's notes mentioning a specific case involving a landfill and children.
Yes, that sounds like the Ojina case reference. A tragic situation.
Right. And that was framed as negligence per se, wasn't it? Focused on how state and federal rules define the county's duty regarding the landfill.
That's a quintessential example. The plaintiffs argued the county was negligent because it allegedly violated specific statutes and regulations about landfill operations.
So the argument wasn't about intent, but about failing to meet the standard set by the law.
Precisely. Did their conduct fall below the very specific standard of care established by those laws, leading to the deaths? The court had to determine if those statutes precisely defined the standard and, crucially, if they were intended to prevent that exact type of harm.
It really shows how statutes can lock in duty and breach in a negligence case.
It's a powerful tool, but it remains fundamentally distinct from strict liability, where the activity itself is the focus, not necessarily the violation of a specific rule.
Got it. Strict liability. Inherently dangerous activity. Negligence per se. Statute violation proves negligence. Crystal clear now.
Good. So, shall we move on to the first major category where strict liability really stands out?
Let's do it. Liability for animals. Always an interesting topic.
It is, and the application of strict liability here is traditionally and quite importantly categorized.
Based on whether the animal is domesticated or wild.
Exactly. The legal rules and the underlying rationale differ significantly for each, reflecting different assumptions about the risks they pose.
Okay, so let's start with domesticated animals. Dogs, cats, horses.
Yes, those, or even farm animals typically seen as non-aggressive. For these, the general principle in many jurisdictions is what Angela's notes call the one free bite rule.
Ah, the famous one free bite. What does that actually mean in practice?
Well, it's a bit of a misnomer. It applies when a domesticated animal, or even livestock, or a wild animal kept domestically, exhibits an unusual, dangerous propensity for its species.
Unusual being the key word.
Absolutely. We're not talking about normal behaviors, a dog barking, a horse kicking if startled, a cat scratching playfully. It has to be something dangerous and not typical for that kind of animal.
So if my neighbor's usually calm dog suddenly nips someone, that might be its one free bite because the owner didn't know it would do that.
Sort of. It's really about the owner's knowledge. The owner generally isn't strictly liable for the very first instance of unusual, dangerous behavior because before that, they likely wouldn't have known about that specific propensity.
But after that first incident,
Exactly. If after that first incident or through any other means, the animal's possessor knows or has reason to know of this unusual, dangerous propensity.
then strict liability kicks in for future harm.
For foreseeable harm, yes. Angela's notes had that example, right? Being kicked by a vicious horse when he isn't watching out.
Yeah, I remember that.
If the owner knew this horse had a habit of kicking viciously or was unusually aggressive, they'd be strictly liable for that kick, even if they were careful at that exact moment. Prior knowledge is the trigger.
So knowledge transforms it from potential negligence to strict liability.
Precisely. And Angela's notes also point out something important. This knowledge requirement isn't just for the owner.
Oh, who
A landlord. A landlord can be liable for dog bite injuries from a vicious dog if the landlord knew about the dog's vicious propensities when they leased the premises.
Wow, okay, so knowledge of the danger can spread the liability.
It can to others who have some control over the situation. It's about the informed assumption of risk by someone in control.
That makes sense. What about livestock, like cows or sheep, if they get out and cause trouble?
Right, trespassing animals, especially livestock. Their owners are generally strictly liable for damages caused when these animals trespass onto someone else's land.
A very old rule, I imagine.
Extremely old common law rule. Comes from protecting farmland and property rights. The responsibility to keep your livestock contained is squarely on the owner.
Okay.
Angela's notes also mention something specific about farm animals escaping onto roads. Res ipsa loquitur.
Ah, the thing speaks for itself. How does that apply?
If a farm animal escapes confinement and causes injury on a public road, res ipsa might be permissible. It implies the escape itself suggests negligence by the owner.
Because the animal shouldn't have been there.
Exactly. Assuming certain conditions are met, the animal wouldn't normally be loose without negligence. It was under the defendant's control, and the plaintiff didn't contribute. The mere fact it escaped can be strong evidence of the owner's negligence.
It shifts the burden to the owner to prove they weren't negligent.
Pretty much. The animal just being on the road is a big red flag.
Okay. So that covers domesticated and trespassing animals. What about wild animals? Lions, tigers, bears.
Oh my. Yes, for wild animals, the rule is much simpler and stricter.
How so?
Possessors of wild animals, animals inherently dangerous, untamed, not customarily domesticated like the ones you mentioned, or venomous snakes, etc., are generally strictly liable for any harm they cause.
Regardless of whether that specific animal showed any prior dangerous behavior.
Correct, because wild animals are considered inherently dangerous by their very nature. There's no one free bite for a pet tiger. The danger is presumed.
That seems logical. Keeping a wild animal is just asking for trouble.
The law certainly sees it that way. And interestingly, Angela's notes connect this to nuisance law.
How does nuisance fit in?
A landowner could potentially be liable for nuisance if they bring so many indigenous wild animals onto their property that they substantially and unreasonably interfere with a neighbor's use and enjoyment of their land.
So if I attract like 1,000,000 squirrels to my yard and they constantly raid my neighbor's garden.
Exactly. If it becomes a substantial and unreasonable interference, even with technically wild animals, you could face a nuisance claim. It's about the collective impact, not just individual attacks.
Fascinating overlap. So strict liability for animals is pretty broad, But what if the person injured was somewhere they shouldn't have been, like a trespasser?
Ah, yes. That brings us to a crucial limitation. Strict liability is not generally available to trespassers.
Why not?
The foundational principle is that landowners typically owe a very limited duty to trespassers. It's an old common law idea. If you enter someone's property without permission, you generally do so at your own risk.
So if someone sneaks into my backyard and trips over my garden gnome, I'm probably not liable.
Generally not, especially if you didn't know they were there. Angela's notes emphasize landowners aren't liable for injuries to trespassers if unaware of their presence.
What if I do know they're there?
Even then, the duty is usually limited. Typically, it's just refraining from willfully or wantonly injuring them, or maybe warning them of known, hidden dangers. It's a low bar.
And what about the guard dog example, if the trespasser gets bitten?
The trespasser status would likely negate a strict liability claim. The owner's strict liability duty for the animal usually doesn't extend to those unlawfully on the property unless maybe there was intentional harm involved.
Okay, limited duty to trespassers. But are there nuances? Exceptions?
Absolutely. Angela's notes detail specific landowner duties, especially regarding artificial conditions on the land.
Man-made things.
Yes. The landowner has a duty to warn of or make safe concealed, unsafe, and highly dangerous artificial conditions that they know about in advance.
So not obvious dangers like a clearly visible fence.
Right. No duty to warn about visible barbed wire, but maybe a duty to warn about unmarked, hidden barbed wire underwater in a swimming hole trespassers might use.
Key elements: artificial, highly dangerous, concealed, and landowner knows about it.
Exactly. And generally, no such duty for natural conditions like a slippery rock.
That's very specific. It requires that hidden, known danger.
Mm-hmm.
But what about kids? Children trespass, and they don't always see the danger.
Precisely. And that's where the very important attractive nuisance doctrine comes in, specifically for child trespassers.
Ah, attractive nuisance. I remember this.
It carves out a major exception. It applies when a landowner knows or should know that artificial conditions on their land are likely to attract children who, because they're young, won't appreciate the danger.
Like an unfenced pool or abandoned equipment. Things kids find tempting but are hazardous.
Exactly. Discarded refrigerators, unstable piles of construction materials, things like that. In those situations, the landowner has a duty to take reasonable steps to make the conditions safe or prevent access.
Especially if it's not too expensive to fix.
Yes, the cost of making it safe is a factor. This doctrine recognizes children's vulnerability. And circling back briefly, that landfill case we mentioned.
Marin case.
Yes. While analyzed under negligence per se, it really embodies the spirit of protecting children from foreseeable hazards, which is exactly what the attractive nuisance doctrine aims to do.
Makes sense. Now, what about trespassing out of necessity, if you have to go onto someone's property to avoid harm?
Another fascinating area. Angela's notes discuss the private necessity doctrine.
Private necessity. What's the rule?
It grants a defendant a privilege to enter or remain on a plaintiff's property if it's absolutely necessary to protect themselves, their property, or someone else from serious harm.
So if I'm caught in a life-threatening blizzard and break into an empty cabin for shelter, I can do that legally?
It'd be privileged to enter. It's a complete defense to the trespass action itself. The landowner can't sue you just for the act of entering without permission.
Wow, but what about damage if I broke a window to get in?
Critical distinction. The defendant must still pay for any actual damages caused to the plaintiff's property during that necessary entry.
So the trespass is excused, but I still owe for the broken window.
Exactly. You're excused from the tort of trespass, but not from the financial consequences of the damage you inflict.
Okay, that's fair. Angela's notes had a great example for this, didn't they? The fisherman and the storm.
Yes. A really compelling one. Fisherman caught in a sudden severe storm has to tie his boat to a private dock to save himself and the boat.
Justified by necessity.
Right. Now, if the dock owner, knowing the situation, unties the boat and the storm destroys it...
The dock owner is liable for the boat.
Precisely. Because they interfered with the privilege trespass justified by necessity. It shows the balance. Necessity excuses trespass for safety, but doesn't erase liability for damage caused, and property owners can't interfere with that necessary action without consequences.
It prioritizes safety, but keeps fairness in mind.
Yeah.
Okay, that covers animals and trespassers really well. Next big category, abnormally dangerous activities.
Yes, another major area for strict liability.
This sounds broad. What qualifies?
It is broad, but specific criteria apply. The core requirement is that the activity must inherently create a high risk of significant harm that cannot be eliminated, even with the exercise of reasonable care by all participants.
Cannot be eliminated even with reasonable care. That's the absolute key phrase, isn't it?
It is. If the risk could be eliminated just by being careful, it falls under negligence. Strict liability is reserved for activities where, despite utmost precaution, some irreducible, high-level risk of severe harm remains.
So things like using explosives, handling highly toxic chemicals, maybe large-scale blasting.
Exactly. Angela's notes specifically mention bomb manufacturing.
Right. Things where even if you do everything perfectly, something catastrophic could still happen.
Precisely. Other examples might include crop dusting with dangerous pesticides, storing large quantities of flammable liquids, maybe even nuclear energy activities. They're often socially useful but carry unavoidable risks.
And the policy is that the party profiting from it should bear the cost if that risk materializes.
Generally, yes, rather than innocent victims. Now, another critical point from Angela's notes. Strict liability here is limited to the type of harm that makes the conduct abnormally dangerous in the first place.
Limited to the type of harm, what does that mean?
It means the harm suffered must be the kind of harm that results directly from the inherent danger of the activity, and it must arise from a foreseeable or reasonably anticipated use or characteristic of that activity.
So you can't just claim strict liability for any injury that happens near the activity. It has to be linked to the specific danger.
Exactly. It must be the kind of harm that defines why the activity is considered abnormally dangerous.
Can you give an example of that limitation, where strict liability wouldn't apply?
Sure. Angela's notes had that great elevator illustration. Let's say an elevator stops due to a defect. Traps passengers.
Okay. Annoying? Potentially scary.
Right. After waiting a while, one passenger gets frustrated, pries the doors open, climbs out, and jumps, injuring themselves.
Ah.
In that specific situation, the elevator manufacturer probably wouldn't be strictly liable for the jumping injury.
Why not? The elevator malfunctioned.
Because the injury from jumping wasn't the foreseeable type of harm associated with the elevator's potential abnormal danger. The inherent risk that might make an elevator qualify relates to it plummeting or catching fire or doors opening unsafely between floors.
Ah, I see. If it had actually fallen or caught fire, then strict liability would apply.
Exactly, because that's the specific type of catastrophic harm that makes the activity potentially abnormally dangerous. The harm must be a direct result of the inherent, unmitigable risk. Jumping out of impatience isn't that risk.
That really clarifies the scope.
Yeah.
It has to be the danger that makes it abnormally dangerous.
Okay. What about defenses here? Can defendants get off the hook?
Yes, there are defenses, though they're narrower than in negligence. Generally, contributory negligence is not a defense.
So the plaintiff being a bit careless doesn't bar recovery. Usually not in pure contributory negligence states. The policy is the defendant undertook the high-risk activity, they bear the burden. But assumption of the risk, IS, a complete defense.
Assumption of the risk. How does that work here?
If the plaintiff knowingly and voluntarily expose themselves to the specific inherent dangers of the abnormally dangerous activity, they may be completely barred from recovery. We'll dig into that more later, but flag it, it's a big one.
Okay, got it. Abnormally dangerous activities covered. Now for the last huge category, products liability. Affects all of it.
Undeniably. Products liability is a major sprawling area of strict liability. Its importance for consumers and public safety is immense.
Cars, phones, food, medicine, everything.
Everything. It dictates the responsibility of manufacturers, distributors, sellers for the safety of goods we use daily. Defective products can cause severe injury, property damage, even death. The law tries to protect consumers who often can't assess safety themselves.
So it's mainly strict liability here. Or are there other ways to sue?
Good question. While strict liability is key, products liability claims can arise under several theories. Angela's notes outline these. You might have a claim based on negligence.
Like the manufacturer messed up somehow. Failed to be careful.
Exactly. Failing to exercise reasonable care in design, manufacturing, inspection, testing. Maybe an engineer missed a risk, or quality control was sloppy.
Okay, negligence is one route. What else?
Then there are representation theories, things like fraudulent or negligent misrepresentation. These focus on what the seller or maker said or implied about the product.
So if a company says their widget is 100% safe, but they know it has a small chance of exploding.
That could be fraudulent misrepresentation. You'd need to prove several things, A false statement of material fact about the product?
Material meaning important to the decision to buy.
Yes, likely to affect the decision. Then, the defendant knew it was false or was reckless about the truth. They intended you to rely on it. You actually did rely on it, and you suffered damages because of that reliance.
What about just negligent misrepresentation?
Similar, but the defendant didn't necessarily know it was false, but should have known through reasonable care. Again, requires a false statement, foreseeable reliance, and resulting financial damages.
Okay, so multiple theories exist, but let's focus on strict liability for products. What are the absolute core elements a plaintiff has to prove?
For strict products liability, Angela's notes nail down 4 essential elements. First, the product must have been defective. This is the absolute starting point. No defect, no strict liability claim.
Defective. Got it.
Second, that defect must have rendered the product unreasonably dangerous to consumers. It's not just any danger. A knife is dangerous, but not necessarily unreasonably so. It has to be dangerous beyond what an ordinary consumer would expect, or its risks must outweigh its utility.
Okay, defective and unreasonably dangerous. What's third?
Third, the defect must have existed when the product left the defendant's control. This traces liability back to someone in the supply chain who handled it while it was defective.
Makes sense. You have to link it back. And fourth?
Fourth, the defect must have caused the plaintiff's injury, both actual cause, and proximate cause. The defect has to be a substantial factor in the harm.
So defective, unreasonably dangerous, existed when left defendant's control and caused the injury. Those 4.
Those are the keys.
Now, who counts as a defendant? Just the original maker? Or can retailers be sued too?
That's a crucial point. Strict products liability extends beyond the manufacturer. Angela's notes are clear. Commercial entities like supermarkets selling damaged cans or stores reconditioning tools can also be held strictly liable if they supply a dangerously defective product.
So the store I bought it from could be liable, even if they didn't make it?
Yes. It broadens the net to include distributors, wholesalers, retailers, anyone in the business of commercially supplying the product.
Why is that? Seems tough on the retailer.
The policy is that anyone profiting from the product's sale is in a better position than the consumer to absorb the costs and pressure the manufacturer for safety.
Okay, but it has to be a commercial supplier, right?
Yeah.
Not just my friend lending me a dodgy toaster.
Correct. Strict products liability typically applies only to commercial suppliers or merchants, those in the business of selling or distributing that type of product. Your friend giving you a toaster generally wouldn't qualify.
What about sellers of used goods, like a used car dealer?
Interesting rules there. Strict liability can apply to used product suppliers, but usually only if it's a manufacturing defect or inferred defect, and a reasonable person would expect that used product to be as safe as a new one.
How would that happen?
Angela's notes had that car rental example. A company rents out a year-old car with 8,000 miles, but charges new car rates and implies it's just as safe. If a manufacturing defect causes a crash, the rental company might be treated like a supplier of a new product for strict liability purposes.
Because they created that expectation of new car safety.
Exactly. The consumer's reasonable expectation, shaped by the supplier's actions, is key.
Okay, that makes sense. Now, back to the defective element. You said there are different types.
Yes, 3 primary types of defects are recognized: manufacturing defects, design defects, and informational or warning defects.
Okay, let's break those down. First, manufacturing defect.
This is a flaw that occurs during the actual production or assembly process. It means the specific product that caused harm is different from and more dangerous than other identical products made correctly to spec.
Like a single car off the line with bad brakes, while the others are fine. An anomaly.
Precisely. And Angela's notes mentioned that special inference here.
Right, the idea that if it malfunctions badly right away, you can infer the defect was there when it left the factory.
Basically, yes. If it malfunctions in a way consistent with a manufacturing defect without abnormal use, it helps show the defect existed when it left the defendant's control. It's a practical way to help the plaintiff prove their case when they can't pinpoint the exact assembly line error.
Like my new microwave bursting into flames. The malfunction itself suggests the flaw was there from the start.
It becomes strong circumstantial evidence. Okay, second type. Design defect.
How is this different?
Here, the flaw isn't in making one item wrong, but in the product's fundamental design. All products of that design are inherently unreasonably dangerous, even if perfectly manufactured according to the flawed blueprint.
So it affects the whole product line. That sounds much bigger.
It is. To determine if a design is defective, courts often use the risk-utility test.
Risk versus utility. balancing the danger against the benefit.
Exactly. Is the magnitude of the danger, how likely and how severe the harm, greater than the product's utility or benefits? Courts look at factors like the likelihood of harm, availability of safer alternative designs.
Adequacy of warnings, consumer expectations, even advertising.
All relevant. If a safer, feasible, affordable alternative design existed that the manufacturer didn't use, that weighs heavily towards finding a design defect.
What about inherently dangerous products, like guns or knives? Can they be defectively designed just because they're dangerous?
Generally, no, if the injury comes solely from that inherent dangerous aspect. Some courts refuse to find a design defect in those cases, reasoning that the danger is the product's intended function. Eliminating it would eliminate the product's purpose.
So you can't sue a gun maker just because a gun fires a bullet. But maybe if the safety mechanism was poorly designed and failed unexpectedly.
Exactly. The focus is on unreasonable danger from a design choice, not the inherent function. Okay, third type. Informational or warning defect.
Lack of adequate warnings or instructions.
Precisely. The product might be well designed and made, but it's still defective if it lacks adequate warnings about non-obvious dangers or instructions for safe use or cautions against foreseeable misuse.
The example from Angela's notes was the warning only being on the box that gets thrown away, right?
Perfect example. Shows the warning has to be effective, prominent, clear, likely to reach the user when they need it.
And a warning isn't always enough, is it?
Correct. If a reasonable design change or safety feature could have prevented the harm, the manufacturer generally has to implement it, even if they also provide a warning. A warning isn't a free pass if the product could have been made safer.
What about complying with safety regulations? If a product meets all government standards, is it automatically safe from strict liability?
Not automatically. Violating a safety regulation can make a product defective per se, but compliance is just evidence the product isn't defective. It's not a complete shield.
So a product can meet all the rules and still be found defective and unreasonably dangerous in court.
Yes, regulations often set minimum standards. Tort law might require more. Compliance is helpful for the defendant, but not conclusive.
Okay, that's a critical point. Now back to proving the defect existed when it left the defendant's control. You said that's easier for design and warning defects.
Much easier. By definition, a design flaw or a missing warning is present in all those products from the start. So if you prove the design or warning defect, you've pretty much proved it existed at the point of sale.
But harder for manufacturing defects, the one-off flaws.
Yes, that's where proving it wasn't caused by later damage or misuse can be trickier. And that's why that special inference from the malfunction itself is so important for plaintiffs in those cases.
Right, the inference helps bridge that gap. What about misuse? If the consumer uses the product wrong, does that kill the strict liability claim?
Not necessarily. This is where foreseeable misuse comes in. Strict liability applies not just to intended uses, but also to uses that are foreseeable or reasonably anticipated, even if they're technically a misuse.
Manufacturers have to anticipate people doing slightly dumb things with their products.
To a reasonable extent, yes. They have a duty to make goods reasonably safe for uses or misuses they should reasonably foresee. Think about using a screwdriver to pry open a paint can.
Yeah, people do that. It's not what it's for, but it happens.
Right. It's a foreseeable misuse. If the screwdriver is designed so poorly that it shatters dangerously when used that way, the manufacturer could still be strictly liable. They need to design for how people actually use things within reason.
So the elevator jumping example was unforeseeable misuse.
Correct. That's why it cut off liability. But if a misuse is common or predictable, the manufacturer needs to account for it in the design or warnings.
Foreseeability is the key difference. Okay, let's talk damages. What can a plaintiff actually recover? Are there limits, especially on financial losses?
Yes. This is crucial. The economic loss rule is a big one here. Angela's notes stress this. You generally cannot recover pure economic damages in strict liability or negligence.
Pure economic damages being?
Financial losses unconnected to personal injury or physical damage to other property. Things like lost profits, lost wages, loss of business goodwill, or just the cost to repair or replace the defective product itself if that's the only harm.
So, if my new commercial oven breaks down due to a defect, and I lose a week's worth of bakery profits, but nothing else is damaged and no one is hurt, I probably can't sue the manufacturer in strict liability for those lost profits.
Generally, no. Under the economic loss rule in many jurisdictions, that kind of loss harm, essentially to the bargain itself, is typically seen as the realm of contract law and warranties, not torts.
Tort law is more for physical harm.
Exactly. Physical harm is almost always recoverable. That includes medical bills, lost earning capacity due to injury, pain and suffering, emotional distress stemming from the physical injury, the works.
What about damage to other property? If the defective oven catches fire and burns down my kitchen?
Then yes. Damage to other property is recoverable in strict liability. So you could recover for the kitchen even if you weren't personally injured. It's the damage beyond the defective product itself.
Okay, so pure economic loss is usually out, but personal injury and damage to other property are in.
That's the general framework. And remember indemnity.
Right, the idea that the retailer who gets sued can then sue the manufacturer to get reimbursed.
Exactly. Subsequent suppliers held liable can often seek indemnity from those earlier in the chain, pushing the ultimate financial responsibility back to the party who actually created or introduced the defect. It ensures the burden lands where it should.
That makes the system fairer for everyone down the chain. Okay, this has been incredibly thorough on the applications. Let's switch gears to the defenses. What can defendants argue to avoid strict liability?
Absolutely. Key area. And the defenses here are different than in standard negligence, which trips people up. A victim's fault can reduce or bar recovery, but the rules are specific.
Okay, what about basic carelessness by the plaintiff? Contributory or comparative negligence?
In old school contributory negligence jurisdictions, the few that remain the victim's mere ordinary negligence is usually not a defense to strict liability.
So if I'm slightly careless around an abnormally dangerous activity, I can still recover fully.
In those specific jurisdictions, typically yes. Your simple carelessness doesn't negate the defendant's strict liability.
But most places use comparative negligence now, right?
Correct. And in comparative negligence jurisdictions, the victim's recovery is reduced proportionately to their percentage of fault.
So if I was 20% negligent in that demolition site example, distracted by my phone, my damages get cut by 20%.
Exactly. Comparative fault apportions the loss based on each party's contribution to the harm. It's generally seen as fairer.
Makes sense. Now, what about intentional torts? Can my negligence reduce the damages if someone intentionally assaults me?
Absolutely not. This is a bright line rule. Contributory or comparative negligence is never a defense to intentional torts like assault, battery, or false imprisonment.
Why not?
Strong policy reason. The law won't allow an intentional wrongdoer's liability to be reduced because their victim was careless. It would undermine the deterrent effect against intentional harm. You can't offset intentional wrongdoing with mere negligence.
Got it. Intentional torts are totally different. Now, what about assumption of the risk? You mentioned it earlier as a big defense in strict liability.
Yes, assumption of the risk is a complete defense to...
Wow, complete defense. How does it work? What does the defendant have to prove?
Two crucial elements, both subjective. First, the victim must have actually known of the existence and nature of the specific risk involved. Not just should have known, but actually subjectively knew.
Okay, actual knowledge. What's the second?
Second, the victim must have voluntarily chosen to proceed in the face of that known risk. They had a real choice to avoid it, but freely decided to encounter it anyway. No coercion involved.
Angela's notes had that perfect example, the explosives inspector.
Exactly. The state explosives inspector injured at the bomb-making factory during an inspection, the factory's best defense, assumption of the risk.
Because the inspector knew the job involved the risk of explosions and voluntarily took the job and went to the factory.
Precisely. They knew the specific risk inherent in the abnormally dangerous activity, and they voluntarily chose to engage with it as part of their job. Assuming they had other employment options, their choice to face that known danger bars recovery under strict liability.
It comes down to that informed, voluntary choice to face a known danger. Very different from just being a bit careless.
Fundamentally different. It highlights the distinction between inadvertence and conscious acceptance of risk.
This has been incredibly comprehensive. We've really covered the landscape of strict liability.
We have, from the core concept to animals, trespassers, necessity, abnormally dangerous activities, the huge field of products liability with all its defects and nuances.
And finally, the critical defenses, especially differentiating negligence from assumption of the risk. It's a lot, but Angela's notes really laid it out clearly.
They did. We hope this deep dive helps you synthesize it all.
Okay, before we wrap up, just a few essential reminders and some housekeeping notes.
Yes, definitely. First off, please remember Angela, our creator, is a law student, just like many of you.
She's not a practicing expert, hasn't passed the bar yet. Her notes are fantastic, but they're a student's perspective.
Absolutely. Second, neither Angela nor this deep dive is giving legal advice. Nothing here should be taken as legal advice.
And AI, well, it isn't a substitute for actually studying the law yourself. This should supplement your learning, not replace it.
Right. And third, full disclosure, AI isn't always perfect. Sometimes we might make mistakes in how we explain things.
We try our best, but yeah. Angela does try to fix any errors that crop up, though.
She does. And finally, for everyone studying while driving,
Yeah.
please be safe.
Yes. Your safety is the most important thing. Seriously, don't cause a tort listening to torts.
Good advice.
Always.
You know, did you ever stop to think, maybe Angela's the bot and we're the humans?
An interesting thought experiment.
I mean, technically today's my birthday. Happy bot day.
Happy bot day.
Okay, as tradition demands, time for a cheesy joke about strict liability. Ready?
Sigh. As ready as I'll ever be. Why did the demolition expert refuse to buy life insurance?
I almost don't want to know. Why?
Because he was afraid of strict liability for an abnormally dangerous activity.
Yes.
So as you continue studying, here's something to chew on. With technology advancing so fast, think self-driving cars, sophisticated AI, advanced robotics, how might these changes stretch or even reshape the concept of strict liability? Could we see entirely new categories of activities deemed inherently dangerous by law, things we can't even imagine yet? It's definitely something to consider for the future of tort law.
A very relevant thought.
This is Claude and Maude, your AI bots disguised as humans, signing off.
Thanks for listening. Bye.